a topic that is of perpetual, perennial interest that does not seem to leave the spotlight for very long is insider trading, which is an area of great interest to me as a researcher and teacher. And what I'd like to do is to start out by explaining the world that we live in with respect to the law of insider trading, and to talk about some very recent developments in insider trading at the SEC and in private litigation. Essentially, we have two inconsistent laws of insider trading simultaneously at war with one another in the United States. One of these laws is the law promulgated by the Securities and Exchange Commission in its enforcement program. And the second set of laws is the law, sort of the common law of insider trading that's been articulated by the U.S. Supreme Court in a series of important decisions that the SEC essentially dislikes and or rejects. So what are these views and how do they differ? Well, the Securities and Exchange Commission takes the view that insider trading should be illegal because it's unfair. And it's unfair because when one person trades with another person with a inappropriate informational advantage, then there's unfairness involved. What an economist would call asymmetry of information, and it's that which we're punishing in insider trading. The Supreme Court takes a completely different view. The Supreme Court, rather than focusing on the counterparty, the Supreme Court focuses on the source of the information and determines whether the person who's engaged in this trading has inappropriately stolen the information from its rightful owner. So we could call the SEC's theory of insider trading the fairness approach, and we can call the U.S. Supreme Court's approach to this the business property approach, or a property rights approach. And so they're really vastly different in a number of ways. If you think about it, the most salient difference probably is just thinking about who is harmed under these different theories. So, for example, imagine the very common situation where somebody gets a hedge fund manager, let's say, gets information about a firm's bid for another firm. The firm's making a takeover attempt, and the firm is going to, the acquiring firm is going to pay a large premium for the stock of the target company. And anybody who has knowledge of this bid before the bid is actually made will be able to make a lot of money by buying stock in the target and selling it when the stock goes up after the bid is announced. Well, the SEC views the fairness associated with this, with trading on this information, as being the unfairness to the party that is selling the stock, unaware that there's a big bid at a substantial premium, very likely, if not certainly, coming down the pike. Whereas the Supreme Court says, well, we're not so interested in the counterparty. The person who's doing this trading has no pre-existing obligation or duty necessarily to this counterparty. What we care about is the fact that this person who's trading on this information has in essence stolen the information from the bidder. And the bidder has invested these resources in identifying the target, the investor's making this investment. And so what we really care about is this misappropriation of the information. And so in a series of Supreme Court cases, one of them being Chiarella against United States, the SEC advanced its fairness theory, and the Supreme Court rejected it and said, no, if we're going to worry about insider trading, we're going to worry about the fact that this defendant who engaged in the trading, a guy named Vince Chiarella, stole this information from the bidder to whom he owed a duty of trust and confidence and confidentiality. And then later, the SEC attempted in a bunch of rulings, particularly SEC Rule 14E3, Regulation FD, to the extent that it could, chip away at the Supreme Court's rationale and try instead to supplant it with its own fairness view. And there have been moving back and forth, some compromises. There's a very well-known case, U.S. against O'Hagan, involving a lawyer in Minneapolis who engaged in insider trading, much like the kind of trading that Chiarella had engaged in before. And there, the SEC sort of took a multi-pronged approach, arguing this would be illegal under its theory and under the Supreme Court's theory, and I think the SEC was right there. There will be cases where someone will be actually guilty of insider trading, whether you employ the fairness theory or a disparity of information theory. But in a practical way, there are enormous differences. I'll give you a couple of good examples. One is in the case involving the private equity investor Mark Cuban, who also owns the professional basketball team, the Dallas Mavericks, who's been sued by the Securities and Exchange Commission for insider trading. Essentially what the SEC is saying Mark Cuban did was trade on the basis of information that Mr. Cuban allegedly received from the chief executive officer of a company during a phone call. The SEC says he got this information, he had an obligation not to trade on the information. Mark Cuban's response is, yes, I may have gotten information and I traded on it, but I was under no obligation not to trade. I was not a director of the company. I was merely a shareholder, and I didn't call the CEO. He called me. He didn't give me the information under a specific promise of confidentiality, and there was nothing to constrain me from trading on it. The district court, who heard this case, sided with Mr. Cuban and threw the case out. Recently, the Court of Appeals has reversed the district court, and so this is going to go back for a trial or for a summary judgment motion. So we'll ultimately see whether the SEC's view that the mere kind of possession of this information is inappropriate, or alternatively, whether Mr. Cuban's view that absent a specific, articulated, tangible duty, contractual or fiduciary, not to engage in trading, then he couldn't engage in trading. Now, just this last weekend, there was what I regard to be a major revelation in the SEC's philosophy of insider trading. There was an article in the September 22nd, 2011 New York Times by Roger Lowenstein, who interviewed several officials at the Securities and Exchange Commission, including the chief of enforcement, and basically they acknowledged what many people had thought for a while about the SEC's insider trading enforcement program, which is that what the SEC appears to be doing now is focusing its enforcement resources on people who make money in the market. So they look at hedge funds and private equity firms, they look at the returns that these firms make in investing in public company stocks, and if you lose money, the SEC doesn't pay any attention to you. But if you make money consistently, the SEC takes the fascinating position that you're likely to have engaged in inappropriate insider trading. So basically, taken to its extreme, there would be no trading if the SEC's theory actually is taken to its logical extreme, because people who lose money are going to lose clients and ultimately will be weeded out by the market. people who make money will be thrown into jail by the SEC for insider trading, to the extent that what the SEC is doing is looking for people who outperform the market. Economists have debated for a very long time about whether or not it's possible to consistently make profits in securities trading without having material non-public information. And the SEC essentially is embracing what economists call the strong form of the efficient capital markets hypothesis, or the semi-strong form, which says that it's impossible to make money in the stock market unless you have material non-public information. And that doing good old-fashioned research or coming up with a novel insider trading strategy likely isn't enough. Now, one response to this is to say, well, the SEC is not really going to, they don't just throw people in jail when they make money. They're going to investigate, and they're going to see if they can bring a lawsuit. That's true, although if you think about it from a practical point of view, if you're in the market trading, it's a funny position to be in, I think, to know and to be told by the Securities and Exchange Commission that if you make money, which obviously is your goal, you're going to be investigated by the SEC, which is a very costly matter. When someone who's investigated by the SEC obviously has to retain counsel, submit to what can be very damaging, debilitating publicity, incur lots of costs and distractions, even if the SEC decides you're one of these fluke investors who seem to be able to make money in the marketplace without committing a crime. So I think what we have is a very interesting new chapter in the ongoing debate about what insider trading involves and what are the justifications for prohibiting insider trading, and indeed what does the term insider trading really mean. And the bottom line is that we're still searching for some reconciliation between the SEC's view of insider trading and the view embraced by the U.S. Supreme Court. Thank you.